Alrighty.
We have launched.
Welcome, everybody. Planet Green Trees. Officially episode 160. We're calling it Due Process, Ex Post Facto, and Lenity. Today's August 8th, 2013. Call numbers 1-347-326-9626. I'm your host, Michael Komorn. As I said, Planet Green Trees, episode 160. With me in the studio to help bring you the most current and up-to-date, really relevant information in the medical cannabis and cannabis reform movement, our friend Chad from the Birmingham Compassion Club.
Good evening. Nice to be here.
You're far away from the microphone. Immediately to his left, we've got David Radoy of Radoy Law.
Hello, hello.
Thanks for being here. And our dear good friend, Dewey. Welcome, Dewey.
Hi, everyone.
I want to give a shout, of course, to Dewey's better half, the best of the two halves, I would say. Just kidding. Pam, hope you're doing well, and you better be listening. Just kidding. And, of course, we have Jamie Lowe of the Third Coast Compassion Club.
Hello.
Major medical marijuana radio producer. Putting the show together, you're going to hear why he gets all the
Accolades.
all the alcohol he wants. Also, the one and only editor-in-chief of the Compassion Chronicles, returning after being away for a while. Welcome back, Rick. Glad to have you here.
Was here last week, too, but that's okay.
I don't remember any of that. We're calling tonight's show Due Process, Ex Post Facto, and Lenity because, as we heard last week in episode number 159, we're calling it Blue Water. There's a timely event that took place on Tuesday. This was just Tuesday. The Court of Appeals heard arguments on a case out of Oakland County dealing with the exact same issue. And as we discussed with our friend Paul Talinda, one of the attorneys in the Blue Water case for the Amstels, we don't know if the Attorney General is going to appeal or not. They may not have to because the issues are ripe and before the Court of Appeals. And we are going to have our special guest tonight, Attorney Stuart Friedman, who, along with Thomas Loeb, offered oral arguments on behalf of the defendants in the clinical relief case. And Stuart is going to be joining us. Stuart happens to be one of the smartest lawyers you'll ever hear from. Very, very smart and really understands constitutional law, textualism, and a lot more. So we're going to hear from him. Also, in breaking news this past week, again at issue, the Department of Community Health, or LARA, and its absolute failure and inability to get their act together. I mean, the list is long, but David Crocker is one of the members on the qualifying conditions panel. He was on the panel first time it convened 4.5 years late, and he's on the new one. He's also a board member of Michigan Normal, and he's going to comment on the latest hearings and his thoughts on the process. Also, Dr. David Crocker is what I would call one of the doctors that exercises the gold standard of certification. I've spoken to him at much length about this, and interesting to our show, in the next upcoming weeks, we're going to be participating in a physician certification series where we're going to be discussing the good, the bad, and the ugly, or those that shouldn't be mentioned, as we address and tackle the medical marijuana certification process amongst doctors. We're hoping to have Dr. Crocker back for that discussion, but tonight he's going to be commenting on the new conditions panel, which has been challenging, to say the least. Also, returning again, our friend Steve Green of the Michigan chapter of the Human Solutions, who is going to be reporting on upcoming court dates for those people in our community that have been dragged in. Other contribution from Rick Thompson and Jamie Lowell and all those that are in the studio. Rick is going to be bringing us the news in a little while. Tonight's show is sponsored by Komorn Law, 1-800-656-3557, the Michigan Medical Marijuana Association, MichiganMedicalMarijuana.org. I want to thank all the moderators and administrators over there who are working diligently to keep a safe, comfortable environment for the community to evolve the conversation about medical cannabis. Some exciting things happening over at that site, by the way. In addition to the full-blown membership, which people can call and participate, sign up for and donate, we also have a caregiver connection for editorial, what is it called? Classifieds, for people looking for caregivers, patients looking for caregivers who want to connect. Those caregivers that have openings can engage over there. Nothing to do with medical cannabis, merely trying to provide relationships for those patients that are in need of a caregiver in light of the McQueen decision.
You can sell your old gear there and all kinds of different things, actually. All kinds of different, just like regular classifieds.
Also, I want to recognize the new store that is associated with the Michigan Medical Marijuana Association, CC Discounts, ccdiscounts.com, competing for the marketplace amongst the cannabis and medical cannabis community. Also, give a shout out to our friend Kevin Spittler of the MedJoint Community Compassion Center of Ostemo, Michigan. Also, the Marijuana Rancher, our good friend, running the Cultural Center down in Detroit. Call there for appointments and curator times. 313-422-5281. Also, the Green Light Clinic, Dr. Kumar Singh, who we met with today. I'm going to talk a little bit about him and what's happening over at the Green Light Clinic, 248-390-0574. Okay, want to get right into it here. We got a lot of exciting guests calling in, and I'm going to talk for a minute. As it goes, and as the issue is timely, and we're going to hear more about this when our guests call in and discuss this in more detail. But one of the basic arguments that has been made, and I'm going to ask David to chime in after I ran for a little while, and we'll come back after the break and get more into this. But one of the arguments that is made for some of these dispensary cases, and I think even that can be made for any person who may have been charged with a violation of the enclosed lock facility that was criminally charged at a time prior to the People versus Ballsma, or even prior to the amendments to the Act. Those alleged violations of the Controlled Substances Act, the bringing of charges, I think much of the law that we're going to discuss tonight is applicable. And what I'm saying is that this case that's before the Court of Appeals is significant because there are many people that were pulled into the system. I mean, if you went back and listened to Planet Green Trees episode 5 through 50, you would hear us talking about how unfortunate it is for these individuals who really, truly have good intentions. We don't talk about it as much anymore because we've gotten used to it and become dull to it. But it shouldn't be overlooked because people are engaging in the medical use of cannabis only because they're using it for medical purposes. And they're being dragged into the system not because they're out intending on violating the law, but because there's a ambiguity or uncertainty that exists. And the shame that we used to go crazy about on the show, I did anyways, was that when this debate takes place of ambiguous behavior, the person supporting the position that they're in compliance with the law gets taken in, and the determination of whether they're right or wrong is decided by the courts or on appeal or as a test case. We've seen it over and over and over again, and this is just patently unfair. It's not right that an individual's liberty should be at issue in a test case. And this brings me to the principle by which much of these decisions have been, much of the analysis and case law that supports the argument for the Court of Appeals, and referencing last week's show 159 with the how the court came to the conclusion that it did in the Amstel decision, but it's what we call, in simple terms, some of the most basic constitutional rights afforded to citizens in the United States and in Michigan. It's called due process. And it's called not to have ex post facto laws applied to individuals where they don't have notice of the criminal behavior by which they are being prosecuted for. And I'm involved in a case right now. I don't want to talk specifically about it, but the arguments that have been forwarded have been things such as, well, in terms of whether it's a dispensary or whether it's an individual who is making transfers, whether they're a patient to patient or whether they're a caregiver to a patient, the question remains, whether it's a dispensary, whether it's in a parking lot, whether it's in someone's home, the question remains, what kind of notice did they have at the time that they may have had their negative encounter with law enforcement? What was the true state of the law at any point in time prior to February 2013 when the Supreme Court laid down the law of the land on what the law is on transfers and who's going to be protected under Section 4 and who isn't? And is it fair to say that anybody had noticed prior to that? And when you look at this, you can look and listen to some of the arguments that have been made. And it was interesting because I've been researching and preparing some briefs myself. I revisited all the old arguments about what the plain reading of the law is. 4E, 4I, 4J are all referencing a need for or a right to or a expression of a right of a person with a card to interact with a patient who's got a card. It all takes place in Section 4. And the question remains that in the plain reading of the law, as we've read it back then, it doesn't change. I still think it means the same things, independent of what the Supreme Court has said. But the question that's more relevant is it fair to say that the Court of Appeals in McQueen, when it ruled in August of 2011, was the state of Michigan given notice of what transfers were going to be lawful or not? The arguments that I've seen forwarded by the prosecutor's offices is sure they were, because McQueen laid down the law at that time, and that was the law of the land. They would argue that dispensaries are legal, and that the only transfers that are lawful are those that are between the registered caregiver, the registered patient, and sales are illegal, that you can't exchange money. But that's not what the McQueen decision said. So if you hear a prosecutor relying on the McQueen decision at any point in time prior to February of 2013, listen to me. The McQueen decision did not address any other transfers other than patient to patient where money was involved. So if your transfer that you're being charged with involved any other types of transactions, a registered caregiver to a registered patient, and I would even argue including patient-to-patient transfers where money is exchanged, I would argue you didn't have notice, and it was unfair to charge you or your loved one with such a crime of violating the public health code, because the state of the law at the time, at any time prior to 2013, was without question unclear. And until such time as the Supreme Court laid down the law, it was unfair to require of the citizens, lay people, to be able to analyze or anticipate or even predict what is lawful and what's not lawful, especially in light of the plain reading of the law, Sections 4E, that a registered caregiver may receive compensation for costs for the sale of marijuana to a registered patient. It's unfair to do so. That is a plain reading, and until such time as the Supreme Court spoke, to expect individuals to be put on notice of such crimes is absolutely unfair. And what further is what you see is that prosecutors are now using the Supreme Court's decision in McQueen from 2013 to prosecute and move forward with criminal allegations related to culpable behavior that existed before 2013. And this, too, is another constitutional principle, which is the ex post facto law, that you're not allowed to use the law retroactively to prosecute people. And if that takes place, there's a due process violation. Further, the same Court of Appeals, many may remember, in a case called People v. Green that was issued 1 week before the Supreme Court spoke in People v. McQueen, it said that patient-to-patient transfers where no money was involved was protected under Section 4. So even if you were trying to predict and understand and even went with the McQueen decision, they themselves articulate protected transfers that are not between individuals that are directly connected through the registry program. And I say all that because now the law is clear. But obviously at the time, any time before February of 2013, it's absolutely unclear in terms of absolutes and how the law is to be interpreted. Furthermore, think about the number of judges that looked at the McQueen decision before it was ruled upon by the Supreme Court. You had Judge Chamberlain in the Circuit Court of Isabella County wrote a very thoughtful opinion, finding that those transactions were protected under Section 4. You had 3 judges look at it on the panel of the Court of Appeals, and 2 of them came up with this, identifying 4 different types of transfers. I know all 3 of them were, it was unanimous. I'm thinking of the King decision. But they all came up with the same opinion, but they did not make a final ruling in any capacity about any other transfers other than patient-to-patient where money was involved. And they specifically said that we acknowledge that the parties are in dispute about all these other types of transfers, but we are choosing not to reach them or render an opinion in that regard. So all of you that are out there that are curious to know what is the law of the land regarding registered caregivers to any registered patient where money is exchanged,
we don't know.
And it's not resolved by this opinion. So the concept here that people should have known and therefore it would be constitutionally allowed to prosecute them is a failed principle. And I also want to say that when you hear a prosecutor discussing or utilizing the McQueen opinion in any criminal case, I suggest you tell your lawyer or remember to argue or mention to the judge that the McQueen opinion was a civil case. That the McQueen opinion, without question, provided due process and notice to the business that was operating. Not individual, but they were brought, two individuals, Taylor and McQueen, were doing business as apothecary.
Compassionate apothecary.
Right. And the action was brought to enjoin that business from continuing to operate. So let's not lose sight of what McQueen was. Furthermore, the McQueen individuals, McQueen and Taylor, were given notice because they were served with a complaint that had been filed in the circuit court that had alleged by the prosecutor's office their issues that they were taking with McQueen and Taylor and the way that business was operating. So they can't say that they didn't have notice, but it exemplifies what notice should be. And when a prosecutor argues that proper notice has been given by the general public, should have known, could have known, and should have predicted what the law of the land was, tell them that that is imaginary notice, that that's not real notice, that notice is a complaint or a grievance or an assertion that what you're doing is inappropriate. And then ask yourself whether those prosecutors that are prosecuting the individuals actually did that. Is there a statement that they've made? Can they be found to be on record notifying the community that if you do this, we're going to arrest you? And then ask them if they think that that's fair. And where were they to notify the public? And how dare they prosecute people when they haven't had proper notice? And we're going to talk more about this, but there's a certain outrage that needs to be revisited, and a certain outrage that I think can't be understated in terms of the way the medical cannabis community has been treated by prosecutors throughout the state when they have not really properly provided a reason or given notice to the individuals to what is behavior that's going to be arrestable or not. That's the rant. We're going to take a quick break here, listen to Planet Green Trees, and we are going to be right back.